Hi, this is Michelle Aiden with Libertas Institute. I'm at the Capitol again with Representative Brian Greene to talk about House Bill 79 regarding private attorney general. First of all, can you explain what the private attorney general doctrine is?
I'll try to do that quickly. That's a great question because when people read the title of the bill, they wonder, what the heck is that? So let me start off with a basic principle that under our Constitution, the Attorney General is supposed to be the defender of the rights of the people in the state. And where another state may be doing something that impacts the right of Utah citizens, or a company, a corporation is doing something that affects our rights, the Attorney General steps in and defends the rights of the citizens of Utah. But where those abuses are being committed by the state itself or a subdivision of the state, the Attorney General's office is conflicted because their constitutional duty is to defend the state. Mm-hmm. So if citizens sue their state or a county in their state or a city in their state because of some perceived constitutional abuses, the Attorney General will defend that governmental entity, leaving nobody to look out for the rights of the citizens. And so years ago, this goes back a couple of centuries, since the origins of this nation, courts have recognized that they have the inherent equitable power to award attorney's fees to an individual who brings a case forward that vindicates the rights of all citizens, or at least a great many citizens. Mm-hmm. That doctrine is called the private attorney general doctrine because the private attorney is actually doing the job that the attorney general would do, but for the fact that it's the state actor being sued. And so the attorney general has a conflict and can't defend the rights of the citizens.
Interesting. Okay. What type of opposition have you faced on this bill?
Well, the opposition has come from those governmental entities that don't want to be responsible for the attorney's fees of those who may sue them and prevail. It's concerning to me because government should not feel it is in conflict with or an opponent of its citizens, and should not want to have that protection where they could just violate the rights of the citizens with impunity. That's essentially what this gives them. By not having the private attorney general doctrine in this state, there is little risk for government entities to violate the rights of citizens, and it's difficult to hold them accountable. Now, I also need to mention that up until 7 years ago, the private attorney general doctrine was utilized in this state. It was recognized by our state Supreme Court and had been utilized a few times, a handful of times. Now, this, you have to keep in mind, this is not something that gets widespread use, and so it's not millions of dollars to the state that we're talking about. But after a couple of counties got dinged through legal actions by citizens for these attorneys' fees, they came to the legislature in 2009 and said, hey, we need to eliminate this so that we can't be sued anymore, or at least if we are sued, we won't be responsible if we lose. And this legislature passed a one-line bill that said, after a certain date, a court in this state may not use or may not award fees based on the private attorney general doctrine. And in addition to the concerns I've already mentioned regarding the ability of citizens to hold their government accountable, I'm concerned that the action by the legislature back in 2009 is unconstitutional. It's an unconstitutional invasion of the legislature into the constitutionally delegated authority of the judiciary, and trying to clip the wings of the judiciary and reduce the power of the judiciary through legislation. And that can only be done constitutionally. But
yeah, no, go ahead.
No, by constitutional amendment was what I was going to say.
Okay. Lastly, why should the public care about this issue?
Well, the public should care for two reasons. One, so that there's an incentive to push back against the government if they feel the government is in violation of its powers and, by extension, violating their rights. But second, to maintain this constitutionally required separation of powers. We don't want to set a precedent where the legislature can just invade the territory of the executive branch or the judicial branch if we don't like something that they've done. If they're constitutionally authorized to take that action, legislative intervention is not the appropriate response.
Great, thank you so much. If you'd like more information or to contact your legislator, just click on the description in the link below.